I think the single most important element to a slip and fall case in Michigan is being able to establish what the defect or dangerous condition was which caused the individual to fall. I think it's important to report the dangerous condition to the property owner when the incident occurred. If you're able to obtain photographs or in some way memorialize how the fall occurred, that's equally important. If it happens at a business owner's property, making an incident report so that there's some type of a writing that identifies what happened, where it happened, and how it happened are also important. As I mentioned, establishing the dangerous condition is important, but probably more important than that is being able to establish that the condition was not open and obvious on casual inspection. Because if that is the case, Michigan law precludes an individual from bringing a lawsuit for slip or trip and falls. The typical example is if you've slipped and fall on snow or ice that is readily apparent. Most people would think that if you've fallen at a business owner's property because they haven't properly cleared the snow from their entranceway, they'd be absolutely responsible. Well, the Michigan Supreme Court, in its infinite wisdom, has decided that those situations are open and obvious, and there's no liability in those cases. Oftentimes in business establishments, when there are situations where someone has slipped and fallen, being able to establish notice or the lack of notice of the condition is equally important. If there are cones that alert you to the condition, then arguably the condition is open and obvious. All too often, property owners don't properly warn their customers when situations are present which create slipping hazards and liability. Well, it's important that the slip and fall occur at someone else's property other than your own. Obviously, you can't sue yourself, but also being able to establish that there's liability coverage so that compensation can be occurred is important. And those are all investigative things that capable attorneys, like the attorneys at Moss and Colella, are there to do for you. You can have liability in a homeowner situation if the defective or dangerous condition isn't properly maintained and you've allowed your residents to fall into a state of disrepair. It can also occur in a landlord-tenant situation, probably even better in that situation because landlords are held to a higher standard than John Q. Public. If the property owner does not have liability insurance, collectability becomes a real issue, and all too often those situations are not ones that are pursued by most lawyers. But as I've indicated, at Moss and Colella, we're willing to take a look at every situation because compensation can be obtained from particular business owners who are financially sound, even if they don't have insurance coverage. Well, the first advice I give to anybody who's been injured is to make sure that they get themselves checked out medically to make sure that their injuries are addressed. In a slip and fall situation, if they're able to communicate with the property owner, they should advise the owner that the incident occurred and to alert them to the particular problem. That way there's notice to the property owner and the incident is recorded in some way. Many situations, property owners have surveillance. Those types of things have to be quickly requested so that they're preserved and not destroyed by the property owner, particularly if they're not advantageous to the owner. I would say that most personal injury firms in Michigan shy away from premises liability cases because of the open and obvious line of cases which provide property owners with clear defenses. At Moss and Colella, we're willing to take a look at every case on a case-by-case basis and then use all of our resources to dive in to establish liability against the property owner, to find the exceptions to the open and obvious defenses, and to make sure that the injured individual has a right to full and fair compensation. I've had some outstanding results with property owners, particularly in the fast food industry, where franchisees at well-known fast food restaurants have failed to maintain their floors and failed to put out caution cones, and people have been injured. We've obtained results approaching seven-figure results in those situations because you have a large volume of foot traffic in and out of those places, and you have people, bringing their food from the counter to the tables. They have a responsibility to maintain the floors, to inspect, to clean, to routinely maintain their business premises. And when they don't, that's when problems occur. Yeah. If they're not willing to put out caution, warnings, or they're not willing to maintain a routine to clean the environment, that's when liability is going to be better established.